My name is Brent Vasseur, President of the McCracken County Bar Association, and I would like to welcome you to the People's Law School. The People's Law School is a program of instruction presented by local lawyers who have volunteered their time. The participating lawyers have many years of experience in the areas of law about which they will be speaking. However, the viewer is cautioned that no advice is intended to be given during the discussions. We recommend that each of you consult a lawyer on a face-to-face basis concerning the merits of your particular case. With that in mind, we hope you enjoy the presentations. Hi, I'm Brent Vasseur with the Paducah law firm of Boswell, Sims & Vasseur, and I'm here today to discuss Kentucky workers' compensation law. With me today is Craig Housman and Sharlott Thompson. I would ask them both to introduce themselves.
I'm Sharlott Thompson. I'm an attorney with Whitlow, Roberts, Houston, and Straub in Paducah. I practice workers' compensation defense and personal injury defense.
I'm Craig Housman. I practice with Jordy Garrett at Housman and Associates. I graduated from Vanderbilt Law School in 1973, and workers' compensation, personal injury, and Social Security disability claims have been a major focus of my practice ever since.
Great. I want to begin today by talking a little bit about a brief history of workers' compensation law in Kentucky, maybe how it came about, the rationale behind what we call the Act. And Craig, I'll let you start with that.
Thank you. In Western Europe, in the 19-teens or something like that, is where the idea began. Kentucky adopted the first Workers' Compensation Act in 1916. And basically, before workers' compensation, claims by injured workers against their employers were the most frequent types of civil litigation in the civil court systems in this country, and Kentucky included. In an effort to try and get those cases out of the court system and to get them resolved with less controversy or less dispute, the Workers' Compensation Act was adopted in order to create an administrative remedy, which is supposed to be more simplified and faster. It changed the law that had been applicable up to that point, and basically it's best thought of as a political compromise. It is a situation where before workers' compensation, in order to get anything, medical bills, any money at all, the injured worker had to prove it was his employer's fault that the employee got injured. Adding to the employee's burden in the court system was the employee had to prove it was no part his fault. Adding to his burden furthermore, he had to prove it was no part a fellow employee's fault. And so the truth of the matter is, before workers' compensation came along, injured workers had to litigate their injury cases in court, and the overwhelming majority of those workers lost, and they got nothing. And so with the increasing industrialization of America and the rising number of industry-related accidents, some other method different from the court system was felt to be desirable. And so workers' compensation was adopted, and it is sort of a no-fault system. It is still part of the system that the worker has to prove that his injury occurred while he was at work and doing his duties, but he doesn't have to prove whose fault it was. In fact, it can be the worker's fault, it can be a fellow employee's fault, it can be the employer's fault, or some combination of the three. It really does not matter whose fault it was in terms of entitlement to basic workers' compensation. Everybody who gets hurt on the job is supposed to be entitled to receive workers' compensation. Now, this put the employers, now they're supposed to be responsible for everybody who gets hurt at work and what they get as part of the political compromise. was the employees cannot take them to court anymore. And even if it was all the employer's fault, the employer gets immunity for any liability other than workers' compensation.
So immunity from what we call common law type lawsuits.
Right.
Okay.
The employee could not collect anything under workers' compensation for pain and suffering. And a lot of people still don't appreciate that, even though that's been the law now for nearly 100 years, is what the employee gets are some, he basically gets his medical bills covered. He gets a subsistence allowance, which amounts to usually 2/3 of what he normally would earn in that job. And he gets some payment that is designed to only partially compensate him for his loss of future earnings as a result of a serious injury.
And we'll talk more a little bit about specific injuries and specific benefits in a moment. Charlotte, Craig had mentioned that he used the words work-related and injury. Is that typically how a workers' compensation type claim begins?
Yes, it is. The injury must be causally related to the employee's work.
Okay. So if I'm at work and I get hurt, does that mean that I'm automatically covered under the Workers' Compensation Act of Kentucky?
If you are performing the duties of your work and your work caused the injury, you would be covered. But for instance, if you happen to have a fever because you have the flu and you pass out because of a high fever and hit your head, it is not your work that caused that injury. It would have been your personal illness, and that would not be covered under the Workers' Compensation Act.
So from what I'm hearing, it sounds like there's at times some disputes as to whether or not some injuries may be work-related or may not. And then would that be an issue that I guess would be litigated through the claims process at some time?
Absolutely. And what happens is if essentially there's sort of a presumption that if the injury occurs at the workplace during normal work hours, that it is compensable. And it's basically the employer's burden to show that the injury had nothing to do with work but was due to causes which were exclusively personal to the employee. For instance, if the employee with the flu who fainted was on a ladder at the time he or she fainted, and the injury occurred because she fell so far, it was the work that had her in the elevated position. So even though what caused her to fall may have begun as being personal, if the nature of the work put her at a place of increased risk or heightened the injury, say someone who is subject to epileptic seizures, which is personal to them, who has a seizure while they're cooking on a grill in the restaurant and they fall onto the grill and they sustain burns. True, the work did not cause the seizure, but the work caused the burns, the workplace. And so there's a whole lot of room for argument, even though they've taken this out of the court system. But it's narrowed the issues a lot.
Let me go back to something real quick. When Craig had mentioned the employer and we've heard the term coverage a couple of times. And Charlotte, this will be a question for you. Is it a requirement that employers in Kentucky have workers' compensation insurance coverage?
Yes, it is a requirement.
Okay. So every employer, under I assume most circumstances, is required to have that type of coverage?
That is correct.
Okay. Let's talk a little bit about the specific benefits that may be due an employee after he's injured. Before I talk about that, though, is when an employee sustains an injury, do they have a duty to inform the employer about that injury?
Yes, they do. That's one of the things that the theory is that it enables the employer to make whatever investigation they need to make, and some of the more altruistic motives are that the employer is supposed to be able to provide medical care for the employee if they know about it early. Whether or not that's realistic or not, it is something that in every work injury case both sides are interested in, is whether or not the employee gave notice. Now, there's a provision in the statute that says the notice has to be in writing and it's got to have A, B, C, and D covered. But there's also a provision in the statute that says that doesn't matter if the employer is not misled, and oral notice will do. One of the things that I sometimes hear from employees is that their employer told them that if they didn't give notice within 24 hours or 48 hours or 72 hours that it's not valid and therefore they're not entitled to workers' compensation. The notice requirement is not a matter of company policy. It doesn't matter what the employer wants. It is what the law requires. And the law requires that the employee give notice, but it's reasonable. Notice as soon as it is, I've forgotten exactly what the language is, but basically it's reasonable. Once the employee knows that they've been hurt at work and it's going to amount to something, they need to tell their employer.
So that would be something, I suppose, that's decided on a case-by-case basis rather than
correct.
some bright line rule.
But the less room for argument from the employee's standpoint, the better off they are. But you know, the employees have a hard choice. The employee who runs to turn in a notice every time they, bang a thumb or cut a finger, get branded as complaining too much. On the other hand, if they don't give notice and it turns out to be something serious, like the cut on the finger gets seriously infected, if they hadn't given prompt notice, they may be in for a heck of a fight to get workers' compensation if they are successful at all.
Great.
And I will have to say the employers that I'm familiar with would much rather the employee report the injury at the onset instead of waiting several months.
Regardless of the severity of the injury?
That is correct.
Okay. Now let's talk a little bit about the workers' compensation benefits that are available to an injured worker in Kentucky. And we'll start with medical type benefits. Craig, what is the criteria for a medical benefit to be covered, assuming that the claim has been accepted as compensable or ordered to be compensable?
The treatment must be what's called reasonable and necessary, and as a result of the subject work injury. And what's reasonable basically depends on whether or not the physician who's attending the employee is prescribing treatment which is a recognized acceptable treatment modality. And one of the problems with Kentucky's workers' compensation system is the requirement that once the medical bills, I think, get beyond $3,000, all the treatment is subject to utilization review. And I think there is much more dispute in the Kentucky workers' compensation system on what's reasonable and necessary medical treatment than you run into with any other source of health coverage.
Let me stop you there for a second. When you said utilization review, what is that? What does that mean?
Well, as a practical matter, what it means is the insurance carrier who's providing workers' compensation has some third party take a look at the doctor's proposed treatment, usually a nurse, or they'll send it to some physician to give them a report on whether or not the proposed treatment is reasonable and whether or not it is related to the injury. And if the report comes back that the physician who's looked at the records, who's located in Florida or Texas or California or wherever, doesn't agree with the physician who's actually seen and talked with the patient, then the workers' compensation carrier will say, we're not going to pay for it. And so then the extent to which the treatment gets provided depends on the extent to which the treating physician is willing to get into an argument in terms of supporting his or her requested treatment. And the truth of the matter is that's becoming increasingly a problem for injured employees and for the physicians who try to help them.
Sharlott, as far as medical expenses that are covered, is there a limit as to the amount?
There is not a limit as to the amount of benefit, medical benefit, an injured employee can receive, so long as the treatment is reasonable and necessary for the cure and/or relief of the work injury. Then the injured employee does have a right to medical treatment.
Okay. What about a time limit, or is there a duration that medical benefits are available to that employee?
That is somewhat a complex question. In the event where you have a work injury and the injured employee litigates his claim or reaches a compromise settlement with the employer, that settlement that settlement agreement would be approved by an administrative law judge, or in the first instance, there would be litigation where the administrative law judge would make a ruling. In that case, the medical benefits are for the lifetime of the injured worker.
So
I'm sorry.
No, I was going to ask, so even if someone is injured maybe as an 18 or 19-year-old, for so long as, if they live to be 90 years old, so long as their medical is what you say reasonable, necessary, and related to the claim, that would be covered.
The statute specifically says for the duration of disability.
Okay.
And, you know, as Charlotte has alluded, it becomes a complex question with the passage of time. If you have a circumstance where a young man loses an arm as a result of a workplace accident, when he's 90 years old, if he needs a replacement prosthesis, there won't be much argument about the employer's insurance carrier paying for it. However, if what we have is a low back strain for which the employee had some treatment 10 or 15 years ago, the passage of time and the fact that normal aging is responsible for some changes in the spine increases the risk and the probability, in fact, that there's going to be an argument about getting the employer's insurance carrier to pay for treatment. And the more time that has gone by, the easier it is for the employer to be successful in getting a utilization review physician to say it's not still related, this is due to the natural aging process. And then it gets to be a weighing of the facts. You know, has the employee had a continuous problem of this same basic nature going on for years and years and years? Had there been any other accidents or injuries? Did they fall off their motorcycle or out of their tree stand in the meantime?
Right.
So there's lots of shades of gray, which is unfortunately what keeps us all busy.
It's very fact intensive.
Okay, so which ultimately, regardless of what one doctor might say and another doctor might say, I suppose it's that administrative law judge that will make the ultimate decision as to whether or not he or she believes that it should be compensable, correct?
That is correct.
Okay.
The
And-
administrative law judge is the fact finder. He acts both as the judge and the jury.
Okay. When we're talking about medical benefits, and Charlotte, I'll throw this question to you. If, as an employee that I'm injured at work, in Kentucky, do I have a choice as to the doctor that I go see for treatment?
Yes, you do have a choice as to the doctor that you see for treatment.
Okay, go ahead, I'm sorry.
I was going to add to that, if as an injured worker you are not pleased with your first choice of physician, you have the right to choose a second physician without any input from the employer. And there is a specific form that you are required to fill out to designate your first physician and then your second physician. And then if for some reason you are not pleased with that physician's care or treatment, you may switch physicians a third time, but at that point you need to have the cooperation and agreement of the employer and or its workers' compensation insurance carrier.
Okay. And I'll pose this question to Craig. Once that employee picks that physician, can they only see that one physician?
Well, there are a couple of points I'd like to make. The one physician that the employee picks is called a gatekeeper in the statute, and that position is usually best served by someone like an internist or a family practitioner or a physical medicine and rehabilitation specialist. Because the gatekeeper is not the only doctor you can see, but the gatekeeper is the one who decides what other specialists are appropriate. And so if the gatekeeper thinks that you first need to go, that the worker needs to go see an orthopedic surgeon, Say you've got a problem that's a pain between the shoulder and the neck, and it could be from either one. And so they may first send the patient to be examined by a specialist in orthopedics to look at the shoulder joint. Then they may decide, well, if that's not it, then I'll send him to a neurosurgeon to see about the problem with the neck. So it's not like the worker has to just pick one doctor and that's the only doctor he or she can ever see. What you have to pick is a gatekeeper. And if I may, one of the things that I run into is the employee has the right to choose, and it's either an unfettered choice of physicians, or if the employer is a member or has in place a managed healthcare network, then the employer can provide a list, and the employee has a right to choose from that list. So if the plant nurse or the insurance claims person tells the injured worker, you need to go see Dr. X, the response is, may I see a list of my choices? Because they really don't have a right to tell you who you've got to go to see for treatment. They have a right to tell the injured employee, we have a managed healthcare network, but one of the requirements for that managed healthcare network is freedom of choice within the plan. And so they can't just have one doctor in that network. There's got to be choice.
And do not those plans have to be pre-approved
Yes.
by
Yes.
the
To be
commissioner?
valid.
Okay.
Yes.
Let's talk now about what we would call indemnity type benefits. And Charlotte, I've heard people use the terms temporary total disability benefits or TTD benefits. Can you tell us real briefly what that means?
Yes, those would be the immediate benefits an injured employee may be eligible to receive. They are intended to replace a person's income at basically 2/3 of the average weekly wage of the employee, which is what Craig mentioned earlier in our segment. There are some statutory stipulations to those benefits. An employee must have been placed off work by a physician. He must or she must remain off work at least 7 days before the temporary total disability benefits are to begin.
Okay. And Craig, I've also heard the term permanent partial or permanent total disability benefits. Can you tell us real briefly what those mean?
Whether it's partial or total, this generally falls under that heading that I was talking about earlier, where it is a partial payment to the employee, which is designed to represent a partial payment to him in place of the income that an employee is presumed to lose over the rest of his working lifetime as a result of a serious work injury.
Okay. And is that something that's either reached by agreement or by the decision of this administrative law judge?
Yes, and it's something that is subject to sometimes very little dispute, sometimes a great deal of dispute, and it's a matter of medical opinion. But at least the current system has everybody supposed to be referencing a particular 613-page medical textbook, which narrows the argument. But
And
it's
from
still,
that textbook, do physicians not pick what we call an impairment rating? And then that impairment rating, I guess, becomes part of a formula
exactly.
used to calculate those benefits.
Exactly. And you would think that if you have the same patient going to two different doctors, that the book, both doctors would come up with roughly the same number. And that was the idea behind selling that to the legislature. But in reality, you can get wildly different numbers from different doctors for the same patient for the same injury.
So again, that would be something that the administrative law judge has to pick.
Right.
Okay. We had talked about the medical benefits, indemnity benefits, and I believe there's also a type of benefit available to an injured worker called vocational rehabilitation benefits. Do either one of you want to tell us real briefly what those are and how they're utilized?
You're welcome to.
If the administrative law judge decides that because of the injury the worker sustained, that worker is not capable physically of going back to performing the type of work that the worker was doing when they got hurt. With that preliminary finding, if the worker asks for it, he is entitled to retraining, vocational retraining benefits. And there's no specific dollar limit on that, but there is a time limit that it's basically 1 year's worth of retraining. But the administrative law judge has the authority to order additional time periods. And so it's something that unfortunately is not taken advantage of by most workers who sustain a significant injury, and it is one of the more valuable parts of the workers' rights, but for some reason or other it is just not often pursued.
And I believe it's valuable to both the employee and the employer, because it allows the employee to rehabilitate and to become an active member of the workforce. That is also helpful to the employer because, for instance, the employee could be rehabilitated and come back to work for that same employer. On the other hand, the injured employee could rehabilitate and then improve his disability and not be quite as disabled as he once was, which is a benefit both to the injured worker and the employer.
And who pays for the vocational rehabilitation?
The insurance carrier, or for the employer, or the employer itself. And this is absolutely in addition to the medical benefits. It is in addition to the income benefits. One of the downsides that used to be that if the worker was awarded partial disability benefits but vocational retraining benefits, the partial disability benefits weren't enough to live on while you went to school for a year. But they did change the law, I think in 2004, to provide that the administrative law judge can order the benefits paid at a higher rate. It's not actually that the worker gets more money, but to get more of it sooner.
It accelerates those benefits.
Right.
So while they're going to school, they have a little bit more money to live on while they're training.
Up to that 2/3 of their average weekly wage.
Real quickly, let's talk about a time frame that an employee has to work under if they're injured. And Craig, why don't you tell us about that?
With respect to a work injury, a physical injury, if the injury occurs within the Commonwealth of Kentucky, the employee has 2 years from the date he or she was injured within which to file a formal claim, or 2 years from the last one of those temporary total disability benefit checks which the employer or its carrier is supposed to send to the employee if they are temporarily totally disabled. If the injury happens outside the boundaries of the Commonwealth of Kentucky, then it is only 2 years from the date of the injury, and the payment of temporary total does not extend the time limit. Bottom line is you need to get advice concerning this within that 2-year time frame. One of the things that is the most widely misunderstood aspect of workers' compensation is even the employee who is not interested in getting dollar income benefits,
The indemnity
benefits. If the employee wants his or her medical coverage to continue, they must either file a formal claim or reach a formal settlement agreement signed by them and the carrier and approved by the administrative law judge within that 2-year time period, because 2 years and 1 day after the time limit runs, the employer owes no more medical.
And they're out of time.
They're out of time.
And so are we.
Sorry.
So I want to thank Craig and Charlotte for being with me here today, and thank all of you for joining the People's Law School. See you next time.